Cell number 9, Mr. Iqbal Bahadur T. Dutt, Public Prosecutor.
So this is an application for challenging the family court order dated 11 February 22, passed in CMA 3302 of 2019.
3302 of 2019.
Yes. Pardon, sir?
330 of 2019.
Yes, sir. 2019.
Interim application for maintenance.
Yes, sir. Now the background is like this: is a petitioner is an army officer. They got married in 2009. Since 2013, the wife is staying separately with the daughter who was born in 2012. Since 2013 date of separation, she has been getting maintenance from the army authorities, though which was refused by the family court at Ahmedabad. The details of maintenance being given, one can see on page number 107. The maintenance was continued to be paid till February 2022.
Page number
107, madam. The complete details are given at the page 109. It is the serial 90. That is the last, because the last order was for 3 years. Madam. This may I continue?
109.
107 to 109. 3 pages are there, giving details of all the maintenance paid from May 2014.
Who has paid this maintenance?
That is what I'm saying. Now, the lady had applied to the army authorities.
No, this maintenance was paid. This maintenance was paid by
the petitioner. It
by
was
the
deducted
petitioner
directly from the salary of the officer and paid to the account of the respondent. And it was by virtue of order of the army, which was based on an affidavit which contained a lot of wrong information, for which was again challenged in the court. A case was filed for wrong information given on the oath on affidavit. So keeping these two minds, both the orders were set aside by Armed Forces Tribunal at Lucknow.
which
By
order?
virtue of these two orders being set aside, an amount of approximately 22 lakh rupees is being held by the respondent, for which a separate case has been filed with the Armed Forces Tribunal at Principal Bench, Delhi, which is 1800-1870 of 21, for recovery of this amount, which has become consequently unauthorized that way. Thereafter, my lord, the AFT Lucknow bench had referred that after cancellation of these two orders, it must be reverted back to the army authorities to process the matter again. So by virtue of this order, on 3rd February 2019, an order came to be passed by the army authorities, and a maintenance of 10% was allocated to the lady starting from 3rd February 2019 for 3 years, with the advice to the lady to approach civil court for permanent solution of the issue. Consequent to that, the Southern Command Authority letter is on. One second, I'll just. My lord, may I request you to see page 66.
Yes.
Para 4. May I continue, sir?
Yes.
Whereas the following facts are taken into account by this headquarter in determining the quantum of maintenance allowance to be granted to the lady. First, professional qualification of the wife, her family background, and her capability to earn and support herself. The detailed examination of the facts of the Armed Forces Tribunal in arriving at the interim maintenance to the lady after hearing the case. C. The fact that the lady has deserted the officer. May Lord may kindly note this. And refuses to live with her husband despite the officer filing a restitution of conjugal rights before the family court, citing her professional ambition and the nature of her husband's job as reasons, which has also been quoted by the lady herself in her letter to the officer dated 16 July 2017. It is also taken into account that the lady was well aware of the nature of the officer's job and his posting to a new location every few years when they entered the wedlock. The closure report of Ahmedabad police in the false case filed by the lady against the officer clearly states that the lady has no intention to live with the officer and has filed false cases against him, which is evidence that the intention of the lady is to harass the officer. And in spite of this observation, the army authorities still granted her 10% of the salary as maintenance. And in this, one more important thing is there. May I continue, sir? Will not.
Yes, so where is the final order? What was the final order?
Of cancellation of order.
Granting 10%?
This is the same. The first paragraph, whereas in exercise of the powers conferred under the section 60I of the Army Act 1950, page 66, first paragraph.
Yes.
In accordance with the judgment of the Honorable Regional Bench, Lucknow, dated Itna, Southern Command has accorded sanction for 10% per month from the pay and allowances of Lieutenant Colonel Saurabh Dutt, Hakimpet, and payment is made to NS Dutt for remaining period for maintenance with effect from the date of order for a period of 3 years. Now, my lord, this was once again, as affidavit was submitted by this lady, not disclosing to the authorities that she has opened a dental clinic and she started a practice. Not only that, she met personally the commander of the petitioner in Secunderabad. She went there with the lady, her mother, as well as the daughter, and pleaded that maintenance must be enhanced and she must get maintenance very fast. It was in October 2018, my lord. And in July 2018, she had opened the clinic functional, and December 2017, she had signed the agreement for hiring the premises for starting the. Even till date, the respondent has not committed to the army authorities that she is having her own dental clinic. So army authorities approached Police Commissioner Ahmedabad for verification of the same. That correspondence has also been placed here. I will just take it once. May I draw attention to page 68.
Yes.
This is a letter written by army authorities asking the respondent to confirm the location and functioning of dental clinic. There was no response. Then another letter, page 69. The army authorities approached Police Commissioner Ahmedabad for verification of the same. And after all this, Police Commissioner sent a report, which is on page 73. Which confirmed the existence of the clinic and also the conduct of page 73. It is written there. May I continue reading in between, sir?
This is a letter from the respondent wife.
No, this is letter from police authorities to army headquarters.
No, 70, you are referring 74?
Page 73, my lord. Page 73. Page 74, I have retyped in the pages at 76A. This is again after the inquiry was conducted. The respondent was so bold that he writes to the police commissioner that on what basis have you confirmed the existence of my clinic to army authorities. That page 76A is the type copy because it was not legible one.
So what was the report of the police inspector?
Police inspector, this page.
What was the report?
Page 73, my lord.
Yes.
It says that, start reading it. A report from police inspector.
So what was the verification in the answer?
For confirmation of the above date, I am reading from in between 1, 2, 3, about 10th para 2 and as that. Have you got it?
Yes, for confirmation of the above detail.
Approximate monthly income verification. For confirmation of the above detail, further investigation done by investigating officer visit at above said address and found that N.S. Dutt is practicing as a doctor at the same address. Also, N.S. Dutt was physically available and found doing practice as doctor at the time of investigation. At the same time, she was informed by investigating officer for verification inquiry and for further investigating questions about her monthly income. Answer was not clear and satisfactory. Also, she denied to reply any answer, statement and inform and clear investigation officer to reply a truth of statement after consult with her lawyer. In further investigation, officer made many mobile calls to her statement for reply, but she did not respond in proper manner and personally visited Ghatlodia police station directly and submitted an application. In reading of the application brief that Anne as Dutt is doing practice, submit a dentist doctor at above given address and her own clinic. So this is reported that verification person Anne as Dutt is doing practice in her own clinic as doctor as the above said address, but about her monthly in practice income, truth is not reported by her, so it is difficult to report her approximate monthly income. So this is how army authorities have confirmed in spite of her. So she has been, with the due respect, have been expressing information deliberately. There have been 3 contempt petitions against her over a period of time, 2 execution petitions, 1 petition for false affidavit, 1 for perjury. Perjury application in the same petition was filed, which was not responded for 2 years. Petitioner approached this honorable court and directions were issued to the family court to pursue the matter. And now, as late as the 26th of this month, the family court had ordered an inquiry into the application, which was filed under section 195 of CRPC, read with section 340. So inquiry has been ordered on 26th. I don't have certified copy, applied for it. As and when it comes, it will be placed on record. So that is the, as far as monthly income is concerned, she has in her income tax return filed, which is on page 84, she has given an income of 2,53,000 per year annum. 2,56,450. This works out to monthly income of about 200. In that affidavit of assets and liabilities, she produced 3 passbooks of 3 accounts. 2 of them were not fully legible, 1 was legible. I have tabled down all the entries there of assets. Those are given at page 105, if my lord may have a look. Page 105. This is given as my written argument to the court.
As per the order of this Headquarters Southern Command dated 3rd February 2019, deducting 10% amount per month to the lady. What was that amount? Exact amount?
That last installment with the increment it kept increasing. It has reached 17,000. Last payment was 17,868. And family court in interim order has increased it to 55,000 and started it from 20th of March 2020, 12th March 2020.
You were paying rupees 17,000.
It was right up to this last installment, and in this case, the payment was not to be made by me. It was deducted by army authorities and sent to our account directly.
Deducted by the army authority from your salary account.
Yes.
And it was directed to be deposited in the account of the respondent lady.
Yes, yes.
Correct.
Yes.
You are paying rupees 17,000 as per this order.
Yeah, that has stopped.
Now the family court has directed to pay rupees 55,000.
Yes, and that 55,000. Other thing is they're paying for 2 years from 2 years back, from 2020.
Normally, from the date of the application, this order would be passed by the court below.
And secondly, sir, I was coming to income. Now, one more point is to be noted that when this, I showed this page number. May I take you to this page, my lord? Page number 105. Now, this order was passed without ex parte. We are not heard. We are asked to give written arguments. Written arguments were taken by the court, but not taken into consideration. In para 7. Also from the efforts, from the affidavit of assets and of the applicant, and as that has submitted to this honorable court, it can be observed that a total of amount of 27,18,496. This was credited to her account in a period of 44 months. I have taken 45, leaving days behind. It works out to 60,411 per month. And in income, she is showing income tax return, monthly income of 23,000.
Now, what was your salary?
But
what was your salary?
Now it must be 175. and two, between one set. This is 10%, my lord. One has to just set 17,680. One more zero to be added. That's all.
You produce your salary slip.
Pardon, sir?
Salary slip was produced by you?
I think-
Salary slip was produced by you?
Yes, sir. It was produced. In fact, in affidavit, I have produced income tax return. I have produced salary slip. I have, and everything beyond that, I have produced this opponent's written arguments. In that, everything is contained. And secondly, there.
This amount at page number 105 shown by you was paid by you to the respondent wife.
Yes,
Voluntarily it was paid?
this 27 lakh.
Yes.
No, sir, 27 lakh is not amount
20,
paid by me.
yes, this amount of rupees 27 lakh 18,496 is in addition to the above mentioned amount of rupees 21 lakh 32.
Yeah, this is 21 lakh 30. This is the amount paid by me by virtue of the maintenance which I am paying for Army headquarters. This asset 27 lakh rupees are the credit entries in her account, which could be
By what order you have paid this amount?
which one, Milord?
Say 27 lakh 18,000.
Milord, once again I will repeat. I read this para 7. I reading again. It is honestly, it can be observed that a total amount of rupees 27 lakh 18,496 is credited in her 3 bank accounts from October 17 to June 21. This amount of rupees is in addition to the amount mentioned. This 21 lakh 32,556 is in some other account of State Bank of which entries are not clear. This is 27 lakh is from her source of income which has gone to the bank. And details are given down below. And this total amount, which if I turn to page 109. Down below is the figure, my lord. 22 lakh 29,857. That is the total amount paid by the petitioner to the respondent today till date as far as maintenance is concerned, starting from February 2013.
Yes.
So I was at this that the amount shown in her IT return, she has deliberately done that. And not only that, my lord, the things which she has put in her application, she has mentioned that my monthly income is 2,50,000 rupees. She has also mentioned that I am making 1,50,000 rupees per month from interest and rent. Then she has also told the court that I am having a flat in Bhopal, ISKCON Platinum. And further, she, just to inflate the thing and I would say waylay the court, mislead the court, she has mentioned that I am having property worth crores of rupees all over India. Whereas it is given on affidavit, I don't have property anywhere in India even of 1 centimeter. I do not have a flat there. I do not have an income of 1,50,000 rupees per month. In fact, the last time the family court asked her, how much amount would be deposited to get 1,50,000 rupees as interest per month? It is just hypothetically she has it. And other interesting thing would be her application is there, my lord. May request you to turn to page 22, my lord. Just to mislead the court and tell them that she needs a lot of money and she must be given a lot of money, she's given her monthly expenditure. And it will be interesting reading. She says, house, municipal tax, electricity, miscellaneous, household expenditure 7,000 rupees, vegetables 4,000, restaurant every month 4,000, snacks for daughter 2,500, household servant 5,000, cook salary 6,000, toiletries 1,000, groceries 500, conveyance 5,000, petrol cost 2,000, clothes accessories 17,000, weekend outgoing 1,500, medical expenses 5,500. In fact, this was questioned and she has not produced a single bill of even 1 paisa. Then page 23, miscellaneous yearly expenditure. Minor Dharya's fees 25,000. She's studying in St. Xavier's Loyola, which is a government aided school. Educational expenses 50,000. Her books 25,000. School dress, clothing 75,000.
Let notice be issued to the other side at present. Settlement is not possible.
So settlement, we have tried so many times, sir. In fact, if you not may give me time, I will just say, we first made an effort before going to any court or anything for 1 year.
No, I remember still that in one matter you were appeared as a party in person.
Yes, sir.
So for custody of minor daughter is there.
Yes, sir. Yes, sir. Yes, sir.
I myself and Justice Kothari were there. Right?
So 1 year we went after that. She did not say till thereafter we filed case of restitution, which lasted for almost 4 years, sir. There she had to do nothing. She had to just come. She did not come. And when we withdrew that, only one letter without she has written for coming, that is 16 July letter of 2017, wherein she says, I will not come because of my professional thing and ambition, which I am very ambitious. And not only that, my lord, she filed a case under DVX in 2016, 3 years after leaving the domestic home. That case was decided in 2019 and we all were acquitted out of that. She filed an appeal, which was again dismissed by district court, sessions court in 2020. Now she has once again filed a criminal revision application in this honorable court, which is pending. And after that, she has not followed it up. We have put an application for early hearing and now it's listed for hearing in the month of June.
Present applicant has challenged the judgment in order dated 11th of February 2022 passed below Exhibit 9 in criminal message application number 3302 of 2019 in favor of the respondents by preferring this revision application under section 397 of the Code of Criminal Procedure, 1973. Right. Third learned advocate appearing from the applicant. Now you are practicing advocate now. On the last occasion, you were appeared as a party in person, I think.
Yes. This is my first appearance.
Okay. We submitted that family court has granted the interim maintenance to the respondent who is not entitled for maintenance under section 125 in bracket 1 in bracket A and under section 125 in bracket 4 of criminal procedure, 1973, and that too for the period when she was getting maintenance granted to her by the army authorities. 4 point. It is further submitted that family court has committed the error in exorbitantly increasing the maintenance from rupees 17,868 per month to rupees 55,000 per month in interim maintenance without giving any opportunity to the present petitioner to present his argument. Full point. That effect of the order is given by the family court from 20th of March 2020 concerning the salary for the month of February 2022. 4 point. It is submitted that the respondent wife is capable of earning being a professional dentist, having her private dental clinic near Swami Vivekananda Circle, Memnagar, Ahmedabad since July 2018. Full point. That respondent has intentionally shown her annual income as rupees 2,56,450 in IT return for AY 2020/2021. where the credit amount comes to rupees 60 lakh for 60,411 per month. Full point. That army authorities had approached the police commissioner Ahmedabad for confirmation of the earning capacity of the respondent as well as practicing as practicing as a dentist. Full point. Issue request for consideration. Let notice be issued to the respondent. For the deputy raise service of notice on behalf of respondent number 1. Notice is issued.
My lord, some interim relief I have prayed for on
See
execution of this
that
order.
whatever the amount you are paying at rupees 17,000 to the respondent wife is deducted by the court below, but
Ji.
family court the same amount is deducted.
Sir,
The family court has taken care that some amount is paid by you or credited in the account of the respondent, which is adjusted by the family court also.
but sir, increase they have done to 55,000, my lord. I'm just praying that for the time that the case is decided, this must be put on hold, and thereafter, as the court decides, we'll go as per that. There is no confusion as far as that is concerned. And also, I have mentioned that as far as maintenance to daughter is concerned, there is absolutely no question at all of any question asked there. As far as the lady is concerned, I'm not putting up proof now to discuss each and every point is discussed to why she is not eligible under 125 1A as well as 125(4) with evidence from the documents. So she's, as it is not eligible, my lord, daughter is eligible, and that being also army officer's daughter, she's entitled to free medical assistance and free facilities in number of ways, which she's not availing in spite of being requested to. So in case
You will continue to pay rupees 25,000 to the wife. Instead of 35,000, you will continue to pay rupees 25,000.
there is no problem. In case you could, court could just mention that it could be towards the maintenance for the child.
Maintenance for the wife, you will pay rupees 25,000. I'm not disturbing at this juncture of granting maintenance of rupees 20,000 to daughter Dhairya. You will continue to pay rupees 20,000 to your daughter as ordered by the family court. But instead of 35,000 to the wife, you will pay rupees 25,000 per month.
So then from 55 to 45,
Whatever maybe.
my lord, it will be quite.
Now 25,000 will be continued. There is no question of reducing any maintenance to the daughter at present.
No. What I'm saying, my lord, in case court gives me 5 more minutes, I will.
This is the ex parte order. I am granting this interim leave to you without hearing the other side also. Order passed by the family court. Below exhibit 9. Granting interim maintenance to the respondent wife dated 11th of February 2022 shall be modified at this juncture to the extent that the petition shall pay rupees 25,000 to the respondent wife continuously till final disposal of the revision application, and also continue to pay the amount of rupees 20,000 per month to the minor daughter Dhairya. After 8 weeks,
Only
After
22
8
lakhs is holding, my lord, unless for which the case is already going on, my lord.
at present I have reduced rupees 10,000 per month.
No, my lord, even if this continues for the duration of the finalization of the case, 22 lakh would be sufficient to adjust this amount.
We'll decide later on. After
Because-
hearing the other party, we'll decide accordingly.
Because after that, recovery will become a problem, my lord.
You will continue to pay rupees 25,000 and 20,000 to your daughter at present.
Okay, obliged.
Next.